Every witness.
Hello.
Judgment secret. Judgment secret.
Page wise adjournment, page 7. Page 7, page wise adjournment, admission matter 47 to 51.
Admission. Yaru Rangigowda. All right. You're for him. You're appearing for appellant. All right. It is submitted that learned counsel for the appellant has certain some inconvenience today and seeks for time. Matter is adjourned. Is this matter? When do you want? Next week? Week after next. ಮಾಡ್ತೀರೇನೋ ಇಬ್ರು ಇದ್ದೀರಾ? When is that? Look at 12/3. Both learned counsels for the appellant as well as respondents submit in unison that the matter could be referred to Lok Adalat for settlement of the dispute. Accordingly, the request matter is referred to the Lok Adalat to be listed on 12/3. Both the parties as well as the learned counsel shall appear before the Lok Adalat on 12/3/2022 without awaiting any further notice.
Page 8, 52 to 62.
Serial number 59 and 60, my lord.
52 Allah. At request of learned counsel for the appellant, list this matter after a week. Inform the other side, Mr. Counsel.
Serial number 59 and 60, my lord.
Yes, Girimalaya.
Pray for a week's time, my lord.
I am for the respondent, my lord.
Serial number
Sir, you have to inform your brother.
Yes,
Ma, I am
who
here, my
appears
lord.
on
I
the
am
other
here,
side.
I am before the court, my lord. I am
In which serial number?
serial number 60, my lord.
60. You
LCR is required.
I am for the respondent.
in number 60.
60.
Yes, my lord.
59 and 60, madam. At request of learned counsel appearing for the appellant, relist this matter after a week or 2 weeks?
After 2 weeks, my lord.
After 2 weeks.
Much obliged.
Yes.
Page 9, 63 to 70.
Serial number 68, my lord. I am appearing for the appellant.
One nimsha, sir. One nimsha.
Oh, sorry,
65.
sir.
Huh? What is your name? You are for the respondent. ಏನು ಕೃಷ್ಣಸ್ವಾಮಿ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀರಾ ಮಾಡಬೇಕು otherwise you should not come and wait here. At request of learned counsel for the respondent number 1, release this matter after. Okay, what is the injury case? 2 weeks. After 2 weeks. Inform the learned counsel for the respondent number 1 at request of learned counsel for respondent number 1. Release this matter after 2 weeks. 30.
Is this item number 70, my lords?
Yes.
I am on VC, my lords.
Yes, Mr. Palakshay.
I am Palakshay. If it is item number 70, LCR is necessary, my lords. This is connected with the 3092 of 2022.
All right. Work out.
This is the appeal filed by the KSRTC.
All right, we will get that file and we'll get the LCRs.
Please,
Get ready in the matter.
Then next week,
Learned counsel Shri Ravi Shankar Shastri submits that there is another connected appeal in MFA 3092 of 2020 arising out of the same judgment, right? Arising out of the same judgment. Hence, registry is directed to list this matter along with MFA 3092 of 2020. The
Serial?
registry is directed to secure the TCRs, trial court records.
Serial number 68, I have sought for adjournment.
And
my
you
lord.
wanted,
I am
sir, any
appearing for
particular
next
My-
week, my lords.
case? And all right. So we'll have it after 2 weeks. Release this matter after 2 weeks. Yes, sir.
ನಂದು 68 my lord. 68 my lord.
ಹೇಳಿ ಏನ್ ಬೇಕು?
ನಾನು ಅದಕ್ಕೆ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕೊಳ್ಳಿ my lord. I'll visit the court. Is a appeal on liability by the insurance company is challenging before this court, my lord.
You are Mr.
Lakshmi Narsappa, my lord. Appearing for
Lakshmi
Mr.
Narsappa.
Venkatesh.
Oh, you are appearing on behalf of him.
Yes, my lord.
Yes, at request of learned counsel for the appellant, release this matter after. You want a 1 week or 2 weeks?
2 weeks, my lord. 2 weeks.
2 weeks.
Please oblige me.
Yes. Huh? Yes. You are claimant or claimant? You want for withdrawal? What is next week? Huh? What's the urgency? EP is pending. What is next? What is? All. Withdrawals you can give. Week after that. What is? What is?
Lakshmi sir, serial number 1. I am Krishna.
Claimant's appeal. Claim petition is dismissed. An injury, na? On. Huh? All right. Issue emergency notice to the respondents.
Serial
Claimant. ಏನಾಗಿದೆ? Enhancement. ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? You are able to hear the court. Enhancement. Dispensation ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಮೈಕ್ ಅನ್ನ ಮೇಲೆ ಮಾತಾಡ್ರಿ. ಅದನ್ನ ಮೈಕ್ ನಿಮ್ಮ ಹತ್ರ ಅಂದ್ರೆ ಬರ್ತದೆ. You don't have to run to the mic. ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡ್ತೀರಾ? We file it and we'll consider. She emergent notice to the respondents.
My lord, court mic is muted, my lord. Court mic is muted, my lord.
Sorry.
Serial number 3.
That's why not able to hear.
You are able to hear?
Yes, my lord.
Yeah, we are able to hear your lordship, but not the court. Court mic is muted.
ಇಲ್ಲ ಬರ್ತಾ ಇದೆ. It is coming. No
ಅಲ್ಲ
problem.
audience advocates to mute ಆಗಿದೆ.
All right.
Advocates in ಬರ್ತಾ ಇಲ್ಲ.
Now you are able to hear. You are able to hear me?
Yes, my lord. Yes, my lord. Very much.
Absolutely.
ಅದು ಆನ್
Yes,
ಮಾಡಿ. ಅಲ್ಲಿ ನಮ್ಮ ಇವರು ಯಾರಿದ್ದಾರೆ?
Serial number 3, my lord.
Yes, serial number
I am for the
3.
appellant in this case, my lord. Claimants appeal for enhancement of compensation, my lord. Case of death, my lord.
Death case.
Yes, my lord.
Notice ಮಾಡಬೇಕಲ್ಲ?
Oblige, my lord. Kindly issue notice to both the respondents.
Emergent notice to the respondents. Just tap that mic. Sir, mic tap ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ. ಆನ್ ಆಫ್ ಮಾಡಬೇಕು. On. It is on? Yes. Claimants appeal.
Still it is muted. Muted through system.
ನೋಡಿ ಮಾ.
It is muted.
ಅದು ಮ್ಯೂಟ್ ಆಗಿದೆ ನಮ್ಮ.
Mute ಆಗಿದೆ ಹೌದು.
ಅಲ್ಲಿ ನೋಡಿ. That is a court mic.
ಕೋರ್ಟ್ ಹೌದು ಮ್ಯೂಟ್ ಆಗಿರೋದು.
Please tap and speak.
No, still it is muted. It is showing as muted.
No, sir, it's not muted.
It is not muted. It is showing as muted.
But yes.
It's not muted. Mathadi, what do you want? Mathadi, sir. What do you want? You're seeking for enhancement on issue emergent notice to the respondents. Claimant. All right. Issue emergent notice to the respondents. In 2 cases are filed. Is it? No, along with there are 2 matters or
Quota number ಇದು.
all right. Issue emergent notice to the respondent. Huh? Next also same. All. Ravi Shankar. So what is the amount? Correct. So you're on the point of negligence. All right. So even if negligence is shifted, it will go between you and the case artisan, right? Managing Director, KSRTC. ನಿಮ್ದು ರಾಯಲ್ ಸುಂದರಮ್ಮ. ಬರ್ಕೊಳ್ಳಿ ಹಾರ್ಡ್. Counsel Shri Ravi Shankar, ಏನು? Your name is Ravi Shankar, yes, on behalf of the appellant insurer. Issue emergent notice to the respondents. Seeking for stay. Huh? You have deposited the entire amount. Correct. Have you deposited the amount, total amount, not a deposit? So you have deposited 25 started. All right. So you will deposit 50%. There shall be stay of execution of the judgment and award dated 2011-2021 passed by the Motor Accident Claims Tribunal and 5th Additional Judge within brackets SC-CH-20 May Hall Unit, Bengaluru in MAs 80 of 2013 till next date of hearing, subject to the condition that the appellant insurer deposits 50% of the award amount. 50% of the award amount. All right. Yeah, before must. Madam, 50% of the amount before the MSCT Tribunal. Other orders on IA1 and the mail barcode. Syed Abdul Zab.
I am for the appellant in this case, my lord. It is
Yes,
a case
Mr.
of injury, my lord.
Yes.
It is a case of injury, my lord.
Yes.
My lord, R1 to
What
be
happened?
discussed with since it is an injury, my lord.
What
The
happened in the
liability
tribunal?
Tribunal has awarded the compensation with 10% negligence on my part. And liability is on the insurer. So R1 is not needed. I'll file dispensation for R1 if lordship permits.
All right, we file that. Issue emergent notice to the respondents.
I'll file in the office, my lord. R1 dispensation, my lord.
R1 we are seeking dispensation. What is the
Yes.
order? Any order against R1?
Nothing, my lord. It is a
He is the owner.
contributor. He is the owner, my lord.
Learned counsel for the appellant submits that he will file he would file an application for dispensation of notice to respondent number 1. Full stop. Notice placing the submission on record. Notice to respondent number 1 is dispensed. KT. Yes. Both matters 9 and 10. Enhancement by the claimant. Emergent notice to the respondents. Both matters. Both claimants, Allah. Even the 11 also. Yes. Pradeep B. Huh? You're challenging the quantum. You deposited. You deposit 50% before. High court or trial court, which is the normally where you deposit before trial, tribunal or high court? Yaar claimants which is the better convenient for the claimants, Mr. Counsel?
Trial court, my lord. Trial court, my lord. Claimants are the trial court. If liability is not
Let us
challenged.
have a standard deposit before the tribunal so that it will be easy for them to. What is your name? Huh? Heard learned counsel. Wakalat idiya? Heard learned counsel Sri Mallikarjun Reddy on behalf of the appellant insurer, who is questioning the quantum awarded by the tribunal. Stop. Orders on IA1. Yeah, ಅದಕ್ಕಿಂತ ಮುಂಚೆ issue emergent notice to the respondents. Orders on IA1. There shall be stay of operation of judgment for 11/21 passed by the second additional district and sessions judge and MACT Hassan in MVC number 1340 of 2018. Subject to the condition that the appellant deposits 50% of the award amount. The same shall be deposited before the MACT within a period of 4 weeks today. Oh, ಎಲ್ಲದರಲ್ಲೂ Jeevan?
Appellant, my lord. Claimant's appeal.
Yes.
The claim petition is dismissed. Case of injury. Claim petition is dismissed, my lord.
Dismissed on what ground?
And sir, some contradictions are the evidence of the claimant. That
Issue emergent notice to the respondents. Will list after service of service.
Insurance appeal on quantum of negligence, quantum and negligence.
Yes.
I'll deposit 50% before the High Court, my lord. The charge sheet is against the driver of the car itself. The claimant is the wife
All
of
right.
the driver.
Yes.
My lord, I'll deposit 50% before the High Court, my lord.
All right. Heard. Learned counsel Sri B.S. Mahesh on behalf of the appellant insurer. You are challenging the quantum.
No, my lord, negligence. My lord, the charge sheet itself is against the car driver. Our claimant is the wife of the car, the driver of the car. Sir, mute ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್, ಕೋರ್ಟ್ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದೀರಿ ತಾವು.
Order on the ground of there being contributory. Contributory or no negligence on your side?
No negligence on my side, my lord. The charge sheet is
There's no negligence on proceedings on his side. Stop. Issue emergent notice aitama. Orders on IA. There shall be stay of further proceedings. The judgment and award dated 24/8/2021 in MVC number 1090 of 2018 passed by MACT and Principal Senior Civil Judge CJM Udupi, subject to the condition that the appellant deposits 50% of the award amount for the MACT.
No, my lord, I'll deposit before the High Court, my lord, because there is no liability on me, according to me. As my lord said, if it is only on quantum, my lord, we will even sometimes concede for withdrawal also, my lord. When it is liability, my lord, we may be permitted to deposit before the High Court.
All right.
Oblige.
Before this court.
Yes, oblige.
This.
Oblige.
What is this compromise, Latif? Where is your opponent?
Pujari.
Huh? But ಅವರಿಲ್ಲದೆ ಹೆಂಗ್ ಮಾಡೋದು ಕಾಂಪ್ರಮೈಸ್? We'll have it day after tomorrow. Next week, Asha, he has to come. There are counsel Sri Latif. You are for the claimant?
And for the
Owner, appearing on behalf of the owner is present before the court physically, and Sri Vishwanath Pujari appearing on behalf of the claimant is not present. Hence, relist this matter after a week or 10 days. Week after a week. Compromise is required because same. I think he may not be there. I think he is not here. You heard his submission, so we'll have it some other day. You are for the. Yeah, who are you? So he claimants appeal. So we'll condone the delay. Barkoli. Dispensation ಬೇರೆ ಇದೆಯಾ? Notice to Arvin. Okay. IA number 1 of 2019, orders on IA 1. It is seen that this application is filed under Section 5 of the Limitation Acts, seeking for condoning the delay of 50 days in filing the appeal. Nimdu, shall I take it as no objection, or you want an order of the court? Huh? All right. Learned counsel Shri Ashok Patil appearing on behalf of respondent number 2, fairly and graciously submits that he would not have serious objection in condoning the delay of 50 days in filing the appeal. Full stop. Having heard the learned counsel and on perusal of the affidavit annexed to the application seeking for condonation of delay, I find sufficient cause and reasons assigned by the appellant for condonation of delay. More so, the delay being not in any way extraordinary circumstances of, hence the delay of 50 days deserves to be condoned. Accordingly, I pass the following order. IA 1 of 2019 is allowed. Delay of 50 days in filing the appeal is condoned. Dispensation ಕೇಳಿದ್ದಾರೆ. Then we cannot. So we'll just say, all right. Which is that other matter? No, this is 2376. 98? That is filed by you. Learned counsel for the respondent to bar insurer has also challenged the liability in MFA number 9894 of 2018. Full stop. Registry is directed to list this matter along with MFA 9894 of 2018. Registry to secure the trial court records.
I appear for the appellant, my lord. In this case, notice,
Yes, madam.
Notice to R4 may kindly be dispensed with, my lord, because it's only quantum that is challenged. And R1 to R3 who are represented are the claimants.
Notice to whom?
R4, my lord, is the owner insured.
Have you filed a memo?
I'll file it before the registry, my lord. I'll send
What
it
about the notice to?
R4.
Oh, it is coming up for notice to R4.
Yes, my lord.
Then R4 is the owner.
Owner, my lord. Owner insured. Liability is
What is
at
the award? What is the order of the tribunal?
tribunal is 12 lakhs, my lord. 12 lakhs and 12 lakhs 46,000 have challenged the quantum. It may be referred to Lok Adalat also, my lord. If they are coming to the Lok Adalat, it can be settled.
Perfect. Yeah, the other side has to come. What's called it? Third. Learned Counsel Srimati Harini Shivananda. You are Harini Shivananda, madam?
Yes, my lord. Harini
On
Shiva.
behalf of the insurer, he submits that the notice to respondent number 4, who is the owner, may be dispensed with. Her oral submission is placed on record. Tribunal, who has held joint liability against the owner as well as the insurer, however, directed the respondent number
2, my lord.
directed number 2 to pay the compensation. Notice to respondent number 4 is dispensed with.
I'm appearing
Avina
for the
Sabaradi.
respondent 3, my lord.
Yes.
There are 360 days delay in filing appeal by the claimant.
Unknown Marana.
Madi Swami, without interest, Madi, my lord.
Yes.
Please.
It is now for condemnation of delay. So you have to say what is the reason for delay. Heard. What is your name? You are having wakalat? Have you filed wakalat this case? Have you filed or you have not filed? Then you be honest and say I have not filed. Heard learned counsel Sri Mrityunjay on behalf of Sri R. Sashidhara for the appellant. Claimants, appellant bar claimants. Orders on IA number 1 of 2019. Mr. Venkatesh.
Lakshmi, I am appearing for Mr. Venkatesh, my lord. My name is Lakshmi Narsappa, my lord.
What?
Lakshmi
Mr.
Narsappa.
Lakshmi Narsappa, shall I take it as you have no objection or you want an order of the court?
Illa, sir. The court order madli without interest to condone madli, sir.
Can we say that you are having no objection?
No objection, Swami. No objection, my lord.
Learned counsel for the respondent. Heard. Heard. His application is filed seeking to condone delay of 362 days in filing the appeal. Learned counsel for the respondent, Sri Lakshmi Narayana. Lakshmi Narsappa Narayana.
Lakshmi Narsappa, my lord. KS.
Lakshmi Narsappa, appearing on behalf of Sri M. Venkatesh, submits that he does not have much objection in condoning the delay. Full stop. I have perused the affidavit annexed to the application. And para 2 of the affidavit clearly narrates the reason and the cause for the delay in filing the present appeal. The cause shown therein is satisfactory and the reasons assigned are acceptable. Full stop. Accordingly, IA number 1 of 19 is allowed. Delay of 362 days in filing the appeal is condoned.
Without interest, my lord.
It is needless to mention. It's needless to mention that in case of the appellant being successful, the appellant will not be entitled to interest on the delayed period.
Please, my
Yes.
lord.
R112. Dispensation R112. Any objection you have?
Illa some. Madi some. Liability is admitted. Madi some.
Madam, orders on memo. Another. Learned counsel for the appellant seeks for dispensation of notice to respondents 1 and 2. Notice to respondents number 1 and 2 is dispensed with at the risk of the appellant. 41 days. 41 days. Madam, same order will This is claimant's appeal. Heard learned counsel Jagdish on behalf of the appellant claimant. Full stop. Orders on IA1 of 2021. This application is filed seeking to condone the delay of 41 days in filing the appeal. Full stop. Learned counsel appearing on behalf of the respondent number 2 insurer does not have much objection in condoning the delay. Full stop. I have perused the affidavit annexed to the application. Application condoning the delay. The reasons assigned therein and the costs shown for the delay in filing this appeal is satisfactory and the same is acceptable. Accordingly, the delay deserves to be condoned. Therefore, IA number 1 of 2021 is allowed. Delay of 41 days in filing the appeal is condoned. Full stop. Next. The counsel for the appellant has filed memo seeking dispensation of notice to R1. Notice to R1 accordingly is dispensed with the risk of the appellant. Eli, number. Adyardo. 6547 is filed by you. (6546) is now this one is filed is by you who is a claimant. 6547 is also by another claimant. Another case. Same order, common order. Common order. Learned counsel submits that MFA 6547 of 2019 is filed, agreed by the same common judgment preferred. Therefore, registry to list this matter along with MFA 6547 of 2019. Surprasad. So, madam, this application for condemnation is standard. Is allowed. You just put that. Yes, sir. Guru Prasad. Insurance. What is your Nimdena? Imdilla. Guru Prasad BR. National Insurance Company. Who appears? You are appearing for national. You are not appearing in this matter. No, you take now that it is served. What is your name? Ravi? Ravish. Ravish Benny. All right. Berkoli. There is no representation on behalf of the appellant. However, the notice to respondent number 2 insurer has been served. Full stop. Learned counsel Sri Ravish Benny appearing on behalf of the panel is present before the court. Hence, he accepts notice on behalf of respondent number 2. Learned counsel for the appellant to serve a copy of the appeal memo along with other connected documents. Release this matter next week. Vijay Kumar. You're taking notice on behalf of the Government Insurance Department, KGID. All right. Yes. What about IA1? 442 days. All right. According. Heard learned counsel Sri Vijay Kumar on behalf of the appellant. Though respondent number 1 is served, there is no representation. However, learned counsel Sri GC Parameshwara DC Parameshwaraya, who is present before this court, accepts notice on behalf of respondent number 1. Oh, all right. Learned HCGPR accepts notice on behalf of respondent number 1, and he seeks time to file his objections to the IA number 1 of 2019. Accordingly, release this matter after 2 weeks. Any order against R2? Dispense ಮಾಡಬಹುದು. The counsel for the appellant seeks dispensation of notice to R2 as there is no liability against the respondent number 2. Notice to respondent number 2 is dispensed with at the risk of the appellant. Some auspicious day, 14th. Connected ಏನು ಯಾವುದು? 8-1. So that is listed on. No. When is it? Any specific date is given for that matter? 14-3. Learned counsel for the appellant submits that. That is filed by whom? Submits that there is another appeal filed in MFA 8104 by another claimant, which is pending before this court. Registry is directed to list this matter along with MFA 8104 of 2019. Yes, Mr. Benny.
R1, see number 22, my lord.
Yes, 22, pass. Shastri.
R2 already HR may kindly be called.
Yes, we will dispense notice to R1. Heard learned counsel for the appellant Sri Sripad V. Shastri and learned counsel for the respondent number 2 Sri Ravish Benny. Learned counsel for the appellant submits that notice to respondent number 1 may be dispensed with. Accordingly, notice to respondent number 1 is hereby dispensed at the risk of the appellant. EI Sanmati. All right. In sense, Sri Ravish Benny, learned counsel Ravish Benny has filed wakalat on behalf of respondent number 2. Registry is directed not to show the name of learned counsel EI Sanmati for respondent number 2. Shantaraj. Shantaraj, who appears for United India Insurance? Yes, madam, you will take notice. Is there any difficulty? All right. What is your name? Geeta Raj. Srimati Geeta Raj. Correct? Yes. According. There is no representation on behalf of the appellant. However, though the respondent number 2 has been served, there is no representation. Full stop. However, learned counsel Srimati Geeta Raj, who is present before this court, and who's in the panel of respondent number 2 accepts notice on behalf of respondent number 2. Relist this matter next week. Learned counsel for the appellant to serve a copy of the appeal memo along with the documents to the learned counsel appearing for respondent number 2. Lingaraj, there's no representation on either side. Release this matter next week. Shastri.
I appeal for the second respondent in this case, Your Lordship. I have no
Yes, madam.
objection. I have no objection to condone the delay of 163 days with no interest for the delayed period, Your Lordship.
Claimant's appeal, eh?
Yes, Your Lordship. For
Your
enhancement,
Shastri, what is your name? K. KV Naik. Third learned counsel KV Naik on Wakalati Diana on behalf of Sri Ravi Shankar Shastri for the appellant claimant. Full stop. Orders on IA1. Madam, good. Okay. IA is allowed delay of 103 days in filing the appeal is condoned.
without any interest, Your Lordship, for the delayed period.
In case of the appellant succeeding, the appellant will not be entitled for interest during the delayed period.
Dispensation to R1 is also sought, Your Lordship, in this case.
Yes. The counsel for the appellant is sought for dispensation of notice to respondent number 1. Full stop. Notice to respondent number 1 is dispensed without the risk of the appellant. Madam, can it be referred to local adat?
Yes, Your Lordship, it can be, Your Lordship.
Heard both learned counsels who in unison submit that the matter could be referred to Lok Adalat. Accordingly, this matter is referred to Lok Adalat to be called on 12/3/2022. Both the learned counsels both the parties along with the learned counsels to appear before the Lok Adalat on 12/3/2022 without awaiting any further notice. Yes, who's appearing? Divisional manager, New India Assurance. New India ತಗೊಳ್ತೀರಾ? Patil, Ashok Patil. Ashok N. ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಿ ತೋರಿಸಿದ್ರಲ್ಲ, ಕರೆಕ್ಟ್ ಇತ್ತಾ? ಎನ್ ಇದೆ, ಕರೆಕ್ಟ್ ಇದೆ. Ashok N Patil. There are several Ashok. Ashok Patil. All right. Third learned counsel Sri Ravi Shankar Shastri on behalf of the appellant claimant. Full stop. Learned counsel Sri Ashok N Patil, panel counsel appearing on behalf of the respondent number 2, accepts notice for respondent number 2. Registry to show the name of learned counsel Sri Ashok N Patil for respondent number 2. Full stop. Orders on IA1. IA1, madam, orders. Delay of 125 days is condoned. Accordingly, IA1 is allowed. No objection. Learned counsel for the appellant seeks for condemnation, dispensation of notice to respondent number 1. Notice to respondent number 1 is dispensed with at the risk of the appellant. Lok Adalat Madana, Mr. Patil. 1 minute. We are still in 26. You are appearing 27. 1 minute. Both the learned counsels fairly submit that the matter could be referred to Lok Adalat for resolution of dispute. Accordingly, this matter is referred to Lok Adalat. Both the parties, along with their respective counsels, shall appear before the Lok Adalat on 12/3/2022 without awaiting any further notice. Yes, sir. Yes. Liabilities on R2. Nakaraja appears for R2. You're the insurer. Then why is the divisional manager name shown when you have already filed Wakalat? Served calling. In view of heard learned counsel Sri Ravi Shankar Shastri on behalf of the appellant claimant, learned counsel K. Nagarajaya who in the panel of respondent number 2 has already filed wakalat for respondent number 2. Registry is directed not to show the name of respondent number 2, that is Divisional Manager, New India Assurance Company, Bangalore. Full stop. Orders on IA1. All right. Orders on IA number 1. IA1 is allowed, delay of 234 days is condoned. However, the appellant will not be entitled to the interest for the delayed period. Full stop. Appellant has sought for dispensation of notice to respondents 1, 3, and 4. Full stop. This notice is dispensed to respondents 1, 3, and 4 at risk of the appellant. Both the learned counsels submit that the matter could be referred to Lok Adalat for resolution of the dispute. Accordingly, this matter is referred to Lok Adalat to be listed on 12/3/2022. Both parties, along with the respective counsel, shall appear before the Lok Adalat on 12/3/2022 without awaiting any further notice from this court. Shivraj Patil, learned counsel for the appellant claimant, has filed a memo seeking dispensation of notice to respondent number 1. Full stop. Notice to respondent number 1 is dispensed with at the risk of appellant. Or barbekalri. We don't know what is his defense. No. Next week when it comes up, if he's here, your friend is here, we will refer it. Yes, Mr. Patil. Yes, madam. Sorry? Yes, proceed further. Waiting for your next submission. Your claimant. All right. What is your name? Nityavi. ಅದು ಮೈಕ್ ಸರಿಯಾಗಿದೆಯಾ ನೋಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಕೇಳಿಸಲ್ಲ ಇಲ್ಲಿ ಆನ್ಲೈನ್ ಇರೋರಿಗೆ. Nityavi. Kumari Nityavi. Yes. Heard learned counsel Kumari Nityavi. Do you have wakalat or you don't have? On behalf of learned counsel Prakash MH for the appellant claimant. So also learned counsel Sri Ashok N Patil for respondent number 1. Full stop. Notice to respondent number 2. That's madam. Orders on IA number 1. 1 is allowed. Condonation of delay of 76 days. Delay of 76 days is condoned. However, appellant will not be entitled to interest for the delayed period. Full stop. Appellant, counsel for the appellant has filed a memo seeking dispensation of notice to R2. Notice to R2 is dispensed with at risk of the appellant. Again, Lok Adalat bad hai na? All right. We'll secure the records. Registry to secure the PCR, trial court records.
In this case, appeal.
I am for the appellant, my lord. I am for the appellant.
Yes.
There is a delay of 95 days in filing the appeal by the APSRTC Corporation, challenging negligence and quantum of compensation.
Vijay Kumar.
Please, my lord.
Respondent 1 to 3, my lordship, in this case.
I am for the appellant, my lord, Vijay Kumar.
Yes.
Delay may be condoned.
All right. You was filed release of amount. Anantram, you have filed.
Yeah, respondent number 1 to 3 is my lordship.
Yes. What is there? Any objection?
My lord, if the records are called for from Bangalore only, my lord, it can be disposed of next week only.
Yeah, division bench appeal is pending, my lordship. Claimant also filed an appeal in number 666 of 2022, my lordship.
Then delay may be condoned and post the matter before division bench.
No, I cannot post it before division bench. Division bench can call this matter.
Yes, my lord.
Please, third learned counsel Sri D. Vijay Kumar.
Number MFA number of something.
666.
On behalf of the appellant, insurer Allah, Mr. Vijay Kumar Nive.
No, corporation, Andhra Pradesh Road Transport Corporation.
For the
Andhra
corporation.
Pradesh Road Transport
Andhra
Corporation.
Pradesh Corporation. Full stop. We'll condone the delay, Mr. Anantram.
Yes, my lordship.
Orders on IA1 of 2019. IA1 is allowed. Delay of 95 days in cost is condoned.
And 50% of the amount may be released, my lordship. Request 4 years action is occurred, my lordship.
What is your contention in this case, Mr. Vijay Kumar?
50% may be released in favor of the claimant, subject to result of the appeal, and my lord, balance 50%, my lord, may be kept in the nationalized bank, my lord, till disposal of the appeal.
You have deposited how much? Full amount?
33 lakhs, 93,000.
93,000 debt.
One nimsham, operate, sir. Yes,
33
Mr. Vijay
lakh
Kumar, you have
93.
deposited 33.
Yes, my lord. 33,93,474.
All right.
Before this honorable court, my lordship.
Before this honorable court, that amount may be kept in nationalized bank.
The counsel for the respondents 1 to 3 has filed a memo seeking for release of the amount deposited by the appellant insurer. Full stop. It is also submitted by the other counsel that another appeal in MFA 666, no?
Yes, my lordship.
Of which year?
22.
666 of 2022.
22.
Preferred by the claimant seeking enhancement.
Yes, my lordship. Enhancement.
Which is pending before the Honorable Division Bench.
Fresh matter, my
Full
lordship.
stop.
Not at least.
It is not in dispute that the appellant has deposited a sum of rupees 33 lakhs 93,474 rupees. Full stop. 50% of this amount shall be permitted to be released in favor of the respondents 1 to 3. The balance 50% of the amount shall be kept in fixed deposit in a nationalized bank for a period of 6 months, and there
Till disposal of the appeal, my lord.
Same shall
6
be
months,
renewed.
again, if it is not renewed, unnecessary, it will be.
Same shall be renewed for the further period till disposal of this. 6 months or after 6 months until disposal
Delay may
of
be
the.
condoned. Delay may be condoned.
Is condoned. Madam, delay condoned. Delay is condoned. Yes, Mr. Suresh. Permission to post before DB since it is submitted that the appeal value of the appeal is more than 15 lakh. Hence, registry to list this matter before the Honorable Division Bench. Full stop. Counsel for the appellant to furnish second set in the matter. What is this recalling application not pressed then? Huh? Which matter you are appearing? Serial number 32. Yeah, for the appellant. What is this application for recalling? So notice to respondent number 2 was dispensed. You want to recall that order? Why? Liability is on respondent number 2. Who's respondent number 2? Huh? Joint liability, you know. You're the claimant. Respondent number 2 being the insurer. He is directed to deposit interest. All right. Cool. Senate Council has filed application IR number 1. CD in filing the recall application. For CD, for condemnation of delay in filing the recall application, same is dismissed as not pressed. IA1 you want to dismiss as not pressed. Orders on IA number 2. Who's Mr. Janardhan Reddy?
Janardhan Reddy for R1.
Orders on IA2 of 2021. Heard Senate Council for the appellant. This application is filed. Seeking to recall the order dated 16/2/2021. Wherein this court passed an order dispensing notice to respondent number 2 at the request of appellant. However, the present application is filed to recall the order dated 16 of the fact that there is a liability on respondent 2, है ना? Only respondent 2. Here respondent number 2. Liability as against respondent number 2 with regard to the interest. Therefore, I deem it appropriate to recall the order dated 16/2/2021. Issue notice to respondent number 2. R2 के recall मारो.
Malad, serial number 33, Malad.
33, Mr. Nagaraj.
Please, Malad, I am here. Malad, this application has been filed by the KSRTC for impleading the owner and insurer of the offending vehicle. Notice has to be issued, Malad, on the application for impleading.
This application is filed by whom?
By KSRTC.
You are the appellant.
Yes, Malad.
Appeal is filed also by KSRTC.
Yes, Malad.
So you have filed it.
Yes, Malad.
You are appearing for? So you are respondent number 1. Issue notice to respondent impleading proposed respondents 2 and 3.
Please, Malad.
Release this. Kelly, they connected next matter. This, so this is filed by you. Anand antida idralli. Okay. So delay of 126 days. Yes, Mr. Nagaraj, we'll allow this.
Yes, Malad. Yes, Malad. Subject to delay of interest.
Shri Nimisreno. You are Anand? Third Learned Counsel Shri K.S. Anand on behalf of the appellant claimant. Orders on IA number 1. IA1 is allowed. Delay of 126 days is condoned. However, the appellant claimant would not be entitled for interest for the delayed period.
Please, Malad.
Vijay Kumar, T. Vijay Kumar and D. Vijay Kumar.
My lord, I am for the respondent, my lord. My lord, there is a delay of 700 and
48 days.
48 days. Delay may be condoned, and my lord, it can be disposed of only my lord, the notional income taken by the tribunal is 7,000 rupees. As per local schedule, my lord, 9,000 rupees. Only with regard to the future loss of income, compensation may be enhanced. Para 17 of the judgment, your last may kindly see. Para 17 of the judgment.
What are you seeking, sir? 1-3. Para 17. How much? 9,000. All right. Accident is of which year? 15.
2015, my lord. 2015.
9,000 is okay, Mr. D. Vijay Kumar.
Yes, my lord.
Yes, what else?
That's all, my lord.
Loss of amenities. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? Where is he state? Where is the doctor said? In evidence. It is not extracted in the judgment. Judgmental bandila the discussion. What has the doctor said? 30,000. PW2. Yes, sir. D. Vijay Kumar.
My lord, except my lord, future loss of income, my lord, no other compensation awarded because my lord, already the tribunal has awarded exorbitant compensation, my lord. Since we have not filed the appeal, my lord,
future medical expenditure 10,000 is awarded by the tribunal.
My lord, here, my lord,
PW2 doctor says 30,000 is required.
But so far he has not undergone any. Let him produce any document, my lord. We are ready to pay whatever the amount they have spent.
Have you undergone anything now?
When they don't produce any document, even after 7 years, let them produce it, my lord.
Doctor has said, sir, if you have undergone now, you give more than that, we'll award.
Because it is a future medical expense, sir. Let them produce it.
He's right. The insurer is right. If you have undergone future, you would have had that whatever you have undergone. But that means that you have not undergone. So we'll only enhance this 9,000 from 7,000 to 9,000.
That's all, my lord.
How many days you were there? Inpatient? 86 days. So what is the towards diet and conveyance? You want to argue, Mr. Counsel? You want to argue further on all these things? I'll hear you. In for?
One commission may make, my lord.
20,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Hospitalization and period, 500.
Another 43,000 is also awarded, my lord.
Yes.
Totally, my lord, it is about 63,000 rupees is on very much on the higher side for the year 2015. Hospital iddu avaru ಏನು ತಿಂತಾರೆ?
So counsel hospital or idra, he will be eating medical diet only, but people will go to him, his family will go to him.
Yeah, that is why, my lord, 63,000. My lord, that is why 63,000, my lord.
Diet and conveyance, I think you can increase some more.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಹಾಸ್ಪಿಟಲೈಸೇಷನ್ ಅಂತೇಳಿ again ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಇಲ್ಲ, attendance charges during hospitalization period 500 into 86. That 500.
One matter is reached before quota number 6. Sorry, just I'll make submission and come back.
Yes.
Quota number 6.
All right, we'll hear you.
Please.
You want to argue further? We can post it next week, or we'll dispose it off. Huh?
My lord,
Yes, Mr. Vijay Kumar, we'll increase that also for some amount. You tell me how much amount?
my lord, because it's already 63,000 is awarded, my lord. Another 5 to 10,000, my lord. Another 5 to 10,000.
10,000 rupees towards
Please, my lord.
diet
Please, my
and
lord.
conveyance.
Please, my lord.
All right. And then this 7,000 will become 9,000, which will loss of later period. That's all. Any
That's all,
other
my lord.
increase?
No, my lord.
Pain and suffering, 40,000 kadme already.
Just the single fracture. But actually, my lord, we should have filed appeal, my lord. The corporation BMTC, it is under loss. It has not filed the appeal. And there is a delay of, my lord,
What is the
appeal
allocation?
is filed. Is there any bona fide in filing the appeal? Your House may kindly see. There is a delay of 748 days, my lord.
What is the claimant doing, sir?
748 days, more than 2.5 years.
No, delayed
2 years.
period, he will not be entitled to interest, Mr. Vijay Kumar.
Maybe, my lord, if he's really agreed, my lord, he would have filed. Why? Such a enormous delay.
No, that is okay. Now we
cannot
will
take
increase another 10,000 for pain and suffering.
Single
That's
fracture
all.
get 30,000 rupees. As your last may kindly see the chart, my lord. Look at the chart. Your last may kindly see what 30,000 only. 30,000. A single fracture.
No, he says there are 2 fractures.
Then another 10,000. Additional 10,000.
That's what I said. So that's what I said. Pain and suffering.
That's why 40,000 is awarded. 40,000 is awarded. 30 plus 10, 40.
The council. What does that chart say? Chart adu.
For first fracture 30,000, another fracture 10,000.
All right, we'll increase on that 7,000 to 9,000. And 10,000 on the diet and conveyance. Please. We'll dispose of the matter.
Please, my lord, without interest on the delayed period.
Yes. Heard learned counsel for the appellant Shri Vijay Kumar. Nive Vijay Kumar. Shri Vijay Kumar T on behalf of the appellant claimant.
My lord, I am D Vijay Kumar.
Yes, and Shri D Vijay Kumar appearing for the respondent insurer. Full stop.
Corporation, my lord, it's a BMTC. It's a corporation,
okay.
BMTC.
For the BMTC corporation and that. BMTC corporation. The main contention of learned counsel for the appellant claimant is that the income taken by the tribunal is erroneous. The same requires to be enhanced in view of the Lok Adalat chart of notional income for the period 2015. Another 2015. Accordingly, income of notional income is to be taken at rupees 9,000 per month as on date of the accident. Full stop. Accordingly, since the claimant was admitted as inpatient for 86 days, the hospitalization charges, the period awarded by the tribunal is 43,000 plus towards diet and conveyance 20,000. I deem it appropriate to increase another 10,000 rupees under this head.
Only 10% was considered.
Hmm. 10% is considered. So what is wrong? How much is the doctor's opinion? Mr. Counsel, you want to argue at length, I can hear you. Now he is agreeing for enhancement from 7,000 to 9,000. and 10,000 rupees on that conveyance and diet charges for hospitalization for 86 days. If you are agreeable, we will go. Otherwise, I'll post it for hearing. You can argue. Huh? Instead of 10%, 11%. If your friend is agreeable, Vijay Kumar, then we can do it. Yes, Mr. Vijay Kumar. Mute madidira. Mr. Vijay Kumar, you have muted the mic.
Please, my lord. Sorry, I was in portal number 6, my lord.
All right, doesn't matter. Now, your friend is arguing that instead of 10%, it should be 11%, as doctor has said, depose 33%.
Please, my lord. Maybe consider, my lord. Maybe consider.
All right. Yes, you are successful in that also.
Please, my lord. I'm sorry, I was in other court also simultaneously.
All right. So the percentage of disability is to be enhanced from 10% to 11% in accordance to 1/3 as taken by
Please, my lord.
PW2 and a doctor. PW2, the doctor who has stated 33%. Stop. Accordingly, the judgment and award of the tribunal is modified to as below. All right. So we have taken it as 11%, 9,000 rupees and 10,000 rupees diet and charges. Detailed reasons will follow. Disposed of. Yes, sir. D. Vijay Kumar, next matter is also yours.
1 minute. In this matter is connected with the MFA. My lord, 7616. It is already there on record, but it is dismissed. My appeal, my lord, there is a delay of 400 days. Delay may be condoned. And my lord, if the records are, record is already there in the connected appeal, records have to be called for, my lord.
You copy ಕೊಟ್ಟಿಲ್ವಂತ ಅವ್ರಿಗೆ ಮಿಸ್ಟರ್ ವಿಜಯ್ ಕುಮಾರ್
ಅಲ್ಲ ಅದು ಕೋರ್ಟ್ ಇಂದ ಹೋಗಿದೆ ಅದು ಥ್ರೂ ಕೋರ್ಟೇ ಹೋಗಿದೆ
ಬಂದಿಲ್ಲ it seems now that she says learned counsel says she has not
I'll
received.
furnish it.
Please furnish one side.
Please my lord.
What is your name, madam? Sunita. You are having wakalat? Learned counsel Srimati Sunita BH appearing on behalf of respondent submits. Then yar appeal idu? This is insurer.
First
API.
one appeal is my corporation, my lord. First appeal is by the corporation.
By the corporation.
Claimant appeal is dismissed already.
All right. Appearing on behalf of the respondent, claimant submits that she has not received the copy of the appeal memo, as also the application seeking for applications. Full stop. Learned counsel for the appellant to furnish one set of copies along with IEs to the learned counsel appearing for the respondent. Release this matter next week. After 2 weeks.
My lord, I had 2 for recalling the order.
Let it come up, sir. You give her a copy.
Please, my lord. Please, my lord.
Maheshwarappa. All right. Maheshwarappa. Barkoli. Heard the counsel for the appellant. This is a claimant's appeal on behalf of the appellant claimant. Learned counsel Sri E.I. Sanmati appearing on behalf of respondent number 3 insurer. Insurer is present before the court physically. Orders on IA number 1 of 2019. IA1 is allowed. Delay of 288 days is condoned. Full stop. However, appellant claimant shall not be entitled to interest for the delayed period. Kailas Sankar. Claimant, where is your friend Govindarajan?
Appear for the second respondent, Mr. Govindarajan, in this matter.
Yes, madam.
The delay may be condoned, but with no interest for the set period.
All right. You are the insurer?
Yes.
Yes. Heard learned counsel Kailash Shankar on behalf of the appellant and
Mr.
Srimati
Padmaja for Mr. Govindarajan.
Srimati Padmaja BS on behalf of Shri Govindarajan for respondent number 2 insurer. Orders on IA number 1 of 2019. IA 1 is allowed. Delay of 38 days is condoned. However, appellant claimant shall not be entitled to interest for the delayed period. Shantaraj, 410 days. Issue emergent notice to the respondents. Notice of Bekano. Issue emergent notice to the respondents. Memo hakidira? This is notice to orders on IU1. IU1 is dismissed as not pressed, as the appeal is in time. The counsel for the appellant has filed a memo seeking dispensation of notice to respondent number 1 owner. Accordingly, notice to respondent number 1 is dispensed. Madam Idara, Madam, you will take notice. Srimati Geeta Raj, Learned Counsel, appearing on behalf of the panel counsel appearing on behalf of respondent number 2 is present before the court physically and accepts notice on behalf of respondent number 2. Learned counsel for the appellant to furnish one set of copies of the appeal along with documents to the learned counsel appearing for respondent number 2. Lok Adalat. Both the learned counsel submitted the matter may be referred to Lok Adalat for resolution of dispute. Accordingly, this matter is referred to Lok Adalat to be listed on 12/3/2022. Both the parties, along with their respective counsel, shall appear before the Lok Adalat on 12/2/2022 without awaiting any further notice. Raghu. Yes, Mr. Raghu, notice. Issue emergent notice. Next matter also. Same. Same. Notice of early. The notice of Bekalri. Yarge. You will take, madam? You will accept? You will. So R1 is. So R2 is insurance. You are the claimant. Third Learned Counsel, Sri Srinivasan MY, on behalf of the appellant claimant. Learned Counsel Srimati Geeta Raj appearing on respondent number, panel counsel for respondent number 2, who is present before the court physically accepts notice for respondent number 2. Learned Counsel for the appellant has filed a memo seeking dispensation of notice to respondent number 1. Since he was placed ex parte before the court below and no liability is cast on him, notice to respondent number 1 is dispensed with. Full stop. Orders on IA number 1. Yes, madam. Orders on IA number 1. IA 1 is allowed. Delay of 220 days in filing the appeal is condoned. However, claimant shall not be entitled to interest for the delayed period. Full stop. Both the learned counsel fairly submitted the matters may be referred to Lok Adalat for resolution of dispute. Accordingly, this matter is referred to Lok Adalat to be listed on 12/3/2022. Both the parties along with the respective counsel shall appear before the Lok Adalat on 12/3/2022 without awaiting further notice. Nagaraj Reddy. Yes. Notice. Issue emergent notice to respondents. Chandrachuda. Yes, sir. Notice. Issue emergent notice to respondents. ನೋಡಿ ಯಾರು ಇಲ್ಲೇ ಇದ್ರೆ ಮಾಡೋಣ ಅವ್ರಿಗೆ. ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕೇನೋ. Third, learned counsel for the appellant claimant. IA number 1 is dismissed as not pressed in view of the fact that the appeal is in time. Issue emergent notice. Yes, Madam Geeta. 7 days. Notice ಹೋಗ್ಬೇಕು. Number. MFA. Okay. So whether not in that notice is taken by you in that. So we'll call this matter along with this. Delay ಇದೆಯಲ್ಲ. Delay I'll notice ಹೋಗ್ಬೇಕಲ್ಲ. We have to follow one consistent issue to the respondent. Learned counsel for the appellant insurer submits that there is another appeal which is challenged by the claimant, is it? By third respondent again in third respondent insurer in MFA 1434 of 2021. Whether in that also stay is granted? When is that matter listed? So you submit the same thing happened in the trial court, you can submit in the execution. So here you will still have to pay. But since delay is there, it notice has to. Yes, Purti. IA1 is to be not pressed in view of appeal being in time. Accordingly, IA1 is dismissed as not pressed. Issue emergent notice. Rangi Gowda, adjourn. Girimalaya.
I appear for appellant, my lord. Claimant appeal for enhancement of compensation, my lord. If the other side is there, it can be disposed of.
Other side, Janardana Reddy. Janardhan Reddy.
Then it can be posted to next week, my lord.
Your claimant.
Claimant, my lord.
Enhancement.
Yes, my lord.
So Mr. Reddy appears for insurer.
Insurance company R1.
He is not here, sir.
Then it can be posted for next week.
Next week you pass over Bekage. Because I may not be sitting in the afternoon. Next week. What is the enhancement you are seeking, minor or major?
Major is there. Major.
Learned counsel for the third learned counsel for the appellant. There is no representation on behalf of respondent number 1. Hence release this matter after a week. Yes, Mr. Patel.
Please, my lord. Please, my lord.
1 minute, sir. 1 minute. Yes. Yes, Chetan. You're the claimant. TM andreno? Already, injury matter, injury case. Correct. Injury case, damage to the motor vehicle. Already, we'll have it next week. At request of both learned counsels, relist this matter. You want next week or week after that? Relist this matter after 2 weeks. What do you argue? Let him understand what is your liability, and whatever is remaining, he will have to bear it. And if you are agreeable, Mr. Patil, in such matters, you can just prepare a memo with the tribunal's memo of this table. Which area you are inclined to enhance, which area is acceptable. If it is jointly acceptable, you can dispose it up quickly. Otherwise, we will have to pass it.
I am for the respondent. I am for the respondent.
Yes.
Yes,
madam.
They have filed a claim for the enhancement appeal. I am for the respondent.
Where is Shankar Prasad?
I don't know, madam.
You are appearing for
Respondent, madam, for the corporation.
Insurer.
Yes, madam.
The claimant's appeal.
Yes, madam.
You are for KSRTC.
Yes, madam.
Illi or ilvalla?
It may be urgent because he has to argue it.
Global compensation ಕೊಟ್ಟಿದ್ದಾರೆ ನಾ
ಅದೇನ ಸಮಯ ಅವರಂದ್ರು he was working as assistant a sub inspector and all his injuries are simple in nature. And second thing is he has not examined the doctor, and other things, all his medical amount has been
whether he is working post retirement.
Yes, he was working. He was drawing a salary of 57 to 58,000 rupees.
So he is not retired.
No, my lord. At that time, he was not retired. And second, all his medical amount has been reimbursed in the Arogya Bhagya of the scheme, which is in the police department. My lord. Hence, the tribunal has awarded only 50,000 as a global compensation.
All right, perfect. There's no representation on behalf of the appellant. However, learned counsel for the respondent insurer Srimati Nirmala yes is present through video conference. Relist this matter next week. Rajarama. Injury. Nagesh Srikanta Rao for R2. You're Srikanta Rao? Ready? Both of you are ready? You're ready? Yes. You're seeking enhancement. Page number? What are the injuries? Mic use ಮಾಡಿ mic use. Let's increase the volume. $30,000. All right. Where is the chart for the pain and suffering? Where is what is the amount normally? Then what is the basis of this? So where does it say that it is grievous? Classified, but you are not examined. Either tenderness, swelling, contusion. Huh? What is grievous here? First one is tenderness, swelling, right parietal region, scalp. What is your avocation? Who are you? 62 years, lady. What is awarded? All right. So you are seeking enhancement in which area? Pain and suffering. Loss of permanent disability and other incidental heads. Loss of amenities 25,000. So what is a disability? Not produced. So that goes. Loss of amenities 25,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Now what are you working as? Maybe sir, if she is working, even 62 years, a lady can work. What have you produced? Your medical expenses, you are satisfied. Actual is given. So no change in 1,15,000. Loss of income during laid up period 25,000. How it is arrived? What is a disability? Even according to that, no disability. Attendant charge. How many days you are in patient? 9 days. 25 ಕೊಟ್ಟಿದ್ದಾರಲ್ರಿ. Only loss of amenities. Under which head? Yes, sir. On amenities. No, she may not have produced 10,000 under amenities. Huh? So together, so what we will do, pain and suffering, normally it is 30,000. So pain and suffering will increase 10,000 and another 10. So 20,000 here and 10,000 there. So totally 35,000. Okay. The appeal is allowed. The order of the tribunal, judgment and award of the tribunal is modified, increasing under the head pain and suffering 10,000 rupees, under the head permanent disability and incidental heads of loss of amenities 20,000. Totally 30,000. 30,000 will be increased. So 220 in the, it is modified from 220 to 250. Reasons will follow. ಇದ್ರಲ್ಲ ಇಲ್ಲೇ Yes, sir. Ready. Bandi, you have calculated. Claimant's appeal, you know. Satish Chandra, you are appearing for the claimant.
I'm appearing for the claimant.
You are appearing for? You are Ravi, yes, sir. Yes.
The individual age around 34 years. He has suffered a fracture of scapula.
Injured was aged 34. Then 54 and. So the second case. So the first one is not appealed. So we are only concerned with the second one, MVC 843, Venkatesh, 34 years, agriculturist. Yes.
The petitioner has examined himself as C21 and produced the user. However, when compared to the whole body, it will be less. That is, the percentage of disability to the whole body is 8%.
How it will be 8%?
Practically 40% is the limit disability. As per the terminology, 1/3
1/3 of 40. So 8 Tribunal is taken it. So that will become 13. 13.3. So if it's 13.3, 13. 13.3, 13.5. It goes to the benefit of the claimant. 13.5.
The Tribunal has considered income.
What is the year of accident? 2017. Yearly there, where is the finding?
Again in paragraph 11, paragraph 10, last page number 8.
Petitioner produce.
Minimum wages per day. Last 3 lines, page number 7.
Last 3 lines. Yes.
Considering the minimum wage.
What was his avocation? Agriculturist. All right. Barber anta bere helidare. Barber. Illa. Barber, agriculturist and barber. You are not produced. Adikenu kottilla. So 200 rupees is taken per day. Notional income is taken, so that should be 11,000. Yes.
11,000 into 13.5 into 12 into 16. It comes to $285,120.
11,000 into 12 into 13.5.
You multiply with 16.
What was his age? 34. So 16. So 16 multiplier correct. Yes. Yes, next. 2,85,000. Correct entry, Mr. Counsel.
Yes,
How many days he was inpatient?
9 days. Was in our inpatient at Mangalore. To and fro charges.
Nursing and attendance, sir.
Attendance charges.
9 days, 9,000 rupees.
Nursing attendance is 9,000 rupees.
Conveyance, sir.
Conveyance is also because over to Manipal is 200 kilometers.
ಎಲ್ಲಿ ಅದು ಕೊಟ್ಟಿಲ್ಲ? No, he need not produce materials for ಬೇಕಾಗಿಲ್ಲ. No. The fact that he was admitted for 9 days is not you are not disputing. It is also not disputed either by you, and Tribunal also has awarded 9,000. Now 9,000 rupees, whether it is correct has to be assessed, whether conveyance is included or not. It admittedly here it is not included. Medical. What is your what is your actual medical expense? Which is that? How the Tribunal? Medical actual whatever is there you have to pay, sir. So you tell, sir, where is your medical?
We are producing the trial court records.
Which is that exhibit? 60 medical bills, sir. Adalla.
Because this is a global matter.
Bidri club agidre no, you have to give your
45 treatment documents. Treatment documents, outpatient card, disability, discharge letters, disability certificate, certificate of 23 prescription, 2 X-rays, 2 X-ray reports, scanning report.
Then the 45 treatment documents andre. What is this? 45 treatment doc.
Audio descriptions. The other case, medical.
We are not concerned with that. What is the amount you are claiming, seeking enhancement? No. Now you are awarded 2,52,000. What in this? What is the enhancement you are seeking in medical and other incidental charges?
I will accept the form of part that is an admission from the medical bill. But the doctors to say that in the future, implants removing is 40,000 rupees.
You have been undergone some surgery?
Some another surgery.
Fracture ಆಗಿದೆಯಾ? ಎಲ್ಲಿದೆ? Have you examined the doctor? Have you examined doctor?
Yes, Lord. We have examined the doctor back to this to be assessed.
ಎಲ್ಲಿದೆ? Where is the evidence of the doctor? Nodi. See, when you come, when you say you are ready for argument, you should be prepared with everything. Without LCR means you should have your own certified copy of the evidence. You should sit with him and agree for certain things. Otherwise, you argue, the court will pass an order on merit. Not like this. Not waste the time of the court. We are trying to dispose of more matters because these are accident matters. Both the learned counsels are present physically before the court. Having heard the learned counsels, registry to secure the TCR. ಎಲ್ಲಿಂದ ಬರಬೇಕು? ಚನ್ನಗಿರಿ. Next week? Release this matter next week. Go through it and see how whatever is possible. Madam Nirmala.
I am for respondent, my lord.
You are ready?
No, I am ready, but the Chetan B is the claimant, my lord.
He's here. He's also ready.
There is, according to me, my lord, all heads have been given, except that some amenities we can give, my lord.
ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇನ್ಶೂರೆನ್ಸ್ ನಾಟ್ ಗಿವನ್ ಅಂತ? ಎಲ್ಲ ರೆಡಿ ಗಿವನ್ ಅಂತಾನೆ ಹೇಳ್ತೀರಾ ನೀವು?
ಎಲ್ಲ ಹೆಡ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ತಾವೇ ನೋಡ್ಬೇಕು ಬೇಕಾದ್ರೆ.
ಎಸ್ ಸರ್. Page. What is the injury? What is your age? 45 years. What is the injury? So fracture. Yes. What is the income? What is your income? What is your vocation? Have you produced anything? What has the tribunal done?
Tribunal has taken 9,000, my lord. He has not produced.
2016.
Stay this 9,500 ಇದೆ, 9,000 ತಗೊಂಡಿದೆ. Not produced any document.
9,500 ಇದೆ, 9,000 ತಗೊಂಡ್ರೆ ಹೆಂಗೆ? ವಾಟ್ ಮೇಡಮ್? ಎಷ್ಟು ತಗೊಳ್ಬೇಕು? 9,500. ನಿಮಗೆ 9,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಕರೆಕ್ಟ್ ಇದೆ ಅಂತಾರೆ ಮೇಡಮ್. 9,500 ತಗೊಳ್ಬೋದಾ ಮೇಡಮ್? Yes. Next. So where is that? Where is the calculation by this tribunal? And if 9,000 is page 22. All right. So loss of income also will increase now.
Yes, 500 ತಗೊಂಡ್ರೆ ಇದು ಚೇಂಜ್ ಆಗುತ್ತೆ.
So this will be 9,500 instead of 9,000.
Multiplier 13 correct ತಗೊಂಡಿದೆ ಸರ್.
Multiplier is correct?
13 ಸರಿ ಇದೆ ಸರ್.
What is the age? 46, 13, correct. Yes. All right. So loss of income due to disability. What is the disability? 15%.
Whole body.
5% is correct.
Sir, yes.
So that loss of income due to disability will change?
Yes.
What is the calculation? ಎಲ್ಲ ಮಾಡಿ ರೆಡಿ ಇವಾಗ ಬರ್ಬೇಕ್ರಿ, ಇಲ್ಲೆಲ್ಲ ಮಾಡೋದು. You should do it in your chamber and bring it here and ready and say this is my calculation and you should share it with your friend. What sir, you are practicing in Bangalore. What is the amount? Tell me. All right, you do one thing, you file a memo. All right, now what is next? Loss of income during later period also will increase. How much? First you come to the second one. Loss of income during later period will also increase because tribunal is awarded 15,000 on the 9,000 rupees. Now we are increasing to 9,500. Just increase agutte. How many days?
3 days.
3 days.
ಅಷ್ಟೇ 3 days
Okay. So 9. ಸರಿ ಇದೆಯೇನೋ?
ಅದೇ 3 ದಿವಸ ಅಷ್ಟೇ ಸಮಯ ಆಗಿರೋದು, ಅಡ್ಮಿಟ್ ಆಗಿರೋದು ಅಷ್ಟೇನೆ.
Pain and suffering.
ಅದು ಅಷ್ಟೇ ಸಮಯ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ, 2 ಫ್ರಾಕ್ಚರ್ಸ್ ಇದೆ.
Madam, what is the compensation on injury for a fracture?
ಅದೇ ಸಮಯ 30,000 ರೂಪಾಯಿ ಫಸ್ಟ್ ಫ್ರಾಕ್ಚರ್ ಗೆ, ಸೆಕೆಂಡ್ ಫ್ರಾಕ್ಚರ್
So 2 ಇದೆಯಲ್ಲ?
2ಕ್ಕೆ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
60 ಕೊಡಬೇಕಲ್ಲ?
60. ಒಂದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವಿಲ್ ಬಿ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ 10 to 15,000. ಇಟ್ ಹಸ್ ಗಿವನ್ 20,000. 30 plus 20 50 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಆಲ್ಮೋಸ್ಟ್.
All right. Medical expenses is actual?
ಅದು ಆಕ್ಚುಯಲ್ ಸ್ವಾಮಿ.
All right. Then what about future medical expenses?
ಅವರು ಕೇಳಿರೋದೇ 25,000 ಕೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. 20,000.
So we can increase, make it 25. Yes, next miscellaneous expenditure ಏನು?
ನರಿಶ್ಮೆಂಟ್ ಅದೆಲ್ಲ ಬರುತ್ತೆ ಸ್ವಾಮಿ, ಅದೆಲ್ಲ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಹಾ.
ಒಂದು ಅಮ್ಯುನಿಟೀಸ್ ಒಂದು ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ. ಅಮ್ಯುನಿಟೀಸ್.
ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ?
ಅದೊಂದು ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ. ಅಮ್ಯುನಿಟೀಸ್
35,000.
ಇಲ್ಲೇ ಸಮಯ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಎಷ್ಟು?
10,000 ಕೊಡಿ ಸರ್.
No, amenities 25,000.
ಇಲ್ಲ ಸ್ವಾಮಿ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. 20,000 ಕೊಡಿ ಸ್ವಾಮಿ.
20,000. All right, file a memo, Mr. Counsel.
ಅದೊಂದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಚೇಂಜ್ ಮಾಡಿ ಲೆಟ್ ಹಿಮ್ ಫೈಲ್ ಇಟ್ ಸರ್. ಇಟ್ ಮೇ ಬಿ
Yes, so income 9,500.
ಅಷ್ಟೇ, ಅದೊಂದು ಲಾಸ್ ಡಿಸಬಿಲಿಟಿ ಒಂದು ಚೇಂಜ್.
Disability will not change. 5% is correct.
ಅಲ್ಲ, ಅದರದ್ದು ಇನ್ಕಮ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಸರ್. 9,000
income will change. That will change. You make that calculation in a memo. Give it to the court officer. And instead of 20,000 future medical expense, we will say 25,000.
Awesome.
Loss of amenities 20,000 will be added.
ಅದೇ.
Body.
ಅದು 25,000 ಪ್ಲಸ್ ಡಿಸಬಿಲಿಟಿ ಒಂದು ಚೇಂಜ್ ಆದ್ರೆ ಆಯ್ತು ಸರ್.
ಹೌದು. ಯಾವುದು? 9,500 into 3.
13
months or 3 days ಏನ್ರಿ?
3 days ಸಮಯ ಅಷ್ಟೇನೆ.
3 days. 3 days. What is the calculation? For 3 days, not 3 months. 3 months under 9,500 into 3 is only 3 days. Is correct. How that 15,000 is calculated?
So disability comes to 1,23,500. If you take the income of 9,500. 1,17,000 ಕೊಟ್ಟಿದ್ದಾರೆ, 1,23,500 ಬರುತ್ತೆ. ಅದು ಒಂದು ಚೇಂಜ್. ಮತ್ತೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ 5,000 ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
Future medical expenses?
ಅದೇ ಸುಮ್ಮನೆ 5,000 ಜಾಸ್ತಿ.
You have implants? Implants.
ಅದಕ್ಕೆ ಕೊಟ್ಟರು. ಇಂಪ್ಲಾಂಟ್ಸ್ ಗೆ ಕೊಟ್ಟಿರೋದು 25,000. ರಿಮೂವಲ್ ಆಫ್
So future medical expense 25,000. Yes. Amenities 20,000. All right. That's all. File a memo.
Much obliged.
Third learned counsel Shri Chetan B on behalf of the appellant claimant and Srimati S Nirmala hearing on behalf of the corporation, you know.
Awesome.
Yes, corporation.
Corporations.
The contention of learned counsel for the appellant that the income ought to have been taken as 9,500 for the accident year 2016, whereas Tribunal has taken 9,000, which is erroneous. Accordingly, income of the appellant claimant is taken as 9,500 per month. The multiplier is adopted by the Tribunal is 13, which is correct. The disability of 5% is correct. The enhancement will be loss of income due to disability 1,23,500. Future medical expenses is enhanced to 25,000 as against 20,000. Loss of amenities is calculated at rupees 20,000. All others. Calculations under the head stand intact. Full stop. Accordingly, appeal is allowed, and the compensation is modified to so and so as against 2,50,000. Memo of according calculation.
Much obliged.
Any delay?
Delay ಇದೆ ಅನ್ಸುತ್ತೆ ಅಲ್ಲ
delay ಇದೆಯಾ?
Delayed interest ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು ಸರ್.
Whether there is any delay, madam?
ಇಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಬಿಡ್ತಾರೆ ಸರ್, ಅದ್ರ ಡಿಲೇ ನಂಬರ್ ಆಫ್ ಡೇಸ್ ಗೊತ್ತೇ ಆಗಲ್ಲ.
No delay, madam.
Much obliged. ಆಯ್ತು.
Appeal for the respondent in this case, Your Lordship.
ಮೈಕ್ ಈ ಕಡೆ ಮಾಡ್ರಿ. ನೀವ್ ಹೇಳೋದ್ ಕೇಳ್ಬೇಕಾ ಇಲ್ಲ ಅವ್ರಿಗೆ? Yes, madam. You are appearing for.
Appeal for the respondent, Your Lordship. Serial number 56, Your Lordship.
56. You are appearing for R2.
Yes, Your Lordship. KSRTC.
What about R1? Anything liability against R1?
No, Your Lordship.
Has been dispensed. So why his name is shown? Only the dispensation.
GPA.
Have you filed any memo? What is your name? What is the avocation? What is awarded by the income? What should be awarded? 2018. Which paragraph? Which page?
51.
Huh? Yes, 9,000 is taken. So this should be 12,500.
He has not produced any document here, his income, Your Lordship.
Madam, 9,000 kottidare. On what basis? On what basis? If he has not produced any income, what should be done by the court tribunal? Notional income ತಗೋಬೇಕಲ್ಲ?
How those?
What is the notional income for 2018?
9,500.
You are taking a guesswork. You are not playing Kaun Banega Crorepati, madam.
No, 9,500.
No, you have chart with you, madam. You are appearing for insurer.
No, KSRTC, Your Lordship.
KSRTC, you should know before you make submission. Yes. What is the injury? ಎಲ್ಲಿದೆ? What is the discussion by the tribunal, sir? Synopsis ಅಲ್ಲಿ ಮಾಡೋದು. Page number? Is this sound coming from, madam? Where is this? Ah. Hmm. Hmm. So 10% awarded by the tribunal. Our 18%, sir. Ah. Was not given here? No, whether it is marked as an exhibit. Ideal disability exhibit P14. What does it say? What does it say? Is 100% loss of and 85% loss of 60% loss of movement at left hand, 60% loss of cover of left hand muscle. There is pain and depleted sensation in the right hand. In view of the above, we have significant study in range of activity of agility in the right hand. We know as a permanent physical impairment of 3 to 4% for right upper limb based on the formula of the You have examined the doctor. Where have you examined the doctor? But where is the evidence of the doctor? Commission PW1 only one examined. Where is the other witness? Examined by commission. He has stated in his affidavit. Whether this is the doctor whom you examined is the treated doctor who treated the patient. Where is his affidavit? It was examined by the court commissioner. Court commissioner early evidence where is this? But madam, whether the doctor was examined?
No, my lord.
Your Sashidhara. Heard letter counsel Michinde on behalf of Shri R. Sashidhar for the appellant and Srimati Lalita for respondent number 2. Registry to secure the trial court record. ವಾಪಸ್ ಕೊಡಿ ನಾವು. Yes, Mr. Sidramaya. Where is Hegde Mulkond? He will come. So you want a Passover? Or you will wait? Because post lunch I may not be sitting. So if he is coming by 1:30, we will take up your matter. We'll take the chance. All right. Passover. An enhancement kelidiralla. But all right, if he comes, we'll dispose it of. Killed. Chandrasekharaya Lalita.
In this case, my lord, appellant is grievously injured. TCR is required, my lord. TCR is required.
TCR required.
Yes, my lord.
All right. Third learned counsel Sri B. Chandrasekharaya for the appellant claimant and Srimati Lalita for respondent. Registry to secure the trial court records. Ellin Barbeko?
Illa Bangalore, son. Bangalore.
Release next week?
Week after next, my lord.
He'll Bangalore in the end.
Agbada.
Your friend Ravi Shankar is laughing. He's a master in this matters. He knows how many hours Bangalore in the birthday from Mysore. How many hours he knows.
Please,
yes. We'll have it next week, sir. Get ready.
Please.
Madam, you also get ready and prepare read the chart. You should keep it with you as appearing in MVC matters. That is the Bible for you. Ready reference it.
Yes,
next. Rishabhendraya. What Mr. Nagesh is doing here? Bassa, adike you are respondent alla. Rishabhendraya yaru? You're you are appearing for? So you are the appellant. You have to come this side. ನೀವು exchange ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? Any compromise of exchange in the status? Then you have to come this side, sir. Otherwise we will get confused. We are in the habit of thinking this is appellant, this is respondent. Yes, claimant's appeal. Insurer, you are appearing for insurance company. So what is awarded? In global compensation. Oriental Insurance Company. Yes, what is your defense?
Only duty of the owner to produce the driving license and also when he has filed the statement, it is only duty to produce the driving permit to the court.
Yes.
This is for the if the permit is not valid, or permit is not there.
So he doesn't have temporary permit also. No permit.
He has not. And if there is any violation of the permit, so then as per the Supreme Court decision, the pay and regular.
Correct. Now, what is the order of the tribunal?
Because this, the decision is 11.
Paragraph 21. But here in this case, it's not so. Insurance company claimed that there is violation of permit. Moreover, the phone number 1 has appeared before the court and has not. It is not the case of the insurance company. If the offending vehicle, article having permit, it is their case if there is a violation of permit. But so far the violation of permit condition is concerned, and vehicle is having so driver has got a valid driving license. They are not proved, but only violation of permit condition. Violation of permit condition, this one in many cases said that they will not be this one ground to reject the insurance company to court that it is not there.
No, Mr. Subendra. Now the order of the tribunal, award of the tribunal is that R2 is directed to deposit the amount. So your grievance is that if there is any claim, if there is breach, that you should have been directed to recover it from him. That is your grievance. That's all. Yes. Which statement is that? We are talking about this Justice Halo Karade and Hemant Chandangod. So if there is violation of permit, then he should not recover from you. No. What does the Honorable Apex Court say? It is a set guidelines, and I don't think it is res integra anymore. That if there is a breach and violation, insurer is liable to recover from you. It is for you to go and prove, and if you are able to establish. Correct.
Here that case it is violation of operating the vehicle that without permit, without obtaining permit. So the what is a private vehicle operate as a transport vehicle. It is evidently the RC has to be cancelled. If it is a violation of permit condition, under section 86 there is a provision, cancel the permit. That has been distinguished.
Distinguished. Read that, sir. Read your you're relying on the division bench of this court, which is which paragraph? Relying on para number 9. 9, huh? Oh, the claim tribunal by impunity.
Deviation of the rules take care of permit does not amount to breach of terms and conditions of the policy, and as such, the insurance company cannot absorb its liability in the company. In support of this condition, he places reliance on conditions. The vehicle in the same person, in support of basically, Rani and others of the before between 2018 is 6422, and the judgment of this court is in the they have considered this for the party and have very the question which arises for our consideration is the case of with regard to the quantum of and also the liability based on the order of the vehicle. It is not in this way that the Mangalata died in day after traffic accident. To ration negligence, as on the date of accident, the vehicle was found in the state care perfect on Bangalore KG, the tribunal held that Mandara Gate, the did not have the permit at all, and the said direction cannot be straight away applied in case of non-renewal of the permit, as on the date of election, but the vehicle being covered being permit under section 5 of section 8 Act. The division bench of this court, in case of so and so, that is as said that offending vehicle having permit the claim in violation of the permit amounts to teaching policy use. However, this judgment is rendered without in the case of command transport private United India Insurance and the division manager United Insurance review of the law laid down by the division of this court. In case of command transport would be National Insurance Limited and United India Limited is said that driving the vehicle in possession outside the restricted zone of the permit does not amount to fundamental statutory infraction, and the insurance company cannot be observed its liability to the
Yes, sir.
56 is very clear now. So permit vehicle.
No, now you examine this judgment with Kodi on copy Kodi, sir. See, if I understand it, I'm not expressing any opinion. The judgment of the division bench of this court says that Amrit Pal's case will not be applicable. Where it says that the outside the restricted zone of permit does not amount to fundamental statutory infraction. No, this case, in your case, you have gone outside, you're having permit. Your case is you're having permit, you're having license, but you're driving in the area which is outside the statutory zone given to you. According to you, that is not an infraction, and even the division bench has held it's not an infraction. So you please check up what does Amrit Pal's case say. What do you have? Furnish one copy. No, it is, we will dispose it off.
Even when it is even it is accepting this view that by producing the permit copy, whether the suppose the vehicle is not at all having a permit, he has paid into value policy is correct, the driving license is correct, then a vehicle can be operated on road without carrying passengers. It is not a private network. What the policy says, a vehicle cannot be operated in violation of statutory provisions of Motor Vehicles Act 1988.
We'll examine that. This court will examine that. Simple thing in your case is that you are having permit, you are having license. Only thing is you have operated in an area which is not permitted to you under the act.
To that extent, matter has not been discussed. Only last paragraph what I read.
No. According to you, you are relying on this division bench judgment in which it says that the violation of the restricted zone, you have gone beyond that, is not an infraction. So therefore, Amrit Pal's case will not apply to you. So therefore, pay and recover will not apply. That is all. So you examine this as I think it is covered.
Sorry. Permit copy is not produced. Then it is for production of permit copy. The matter has to go back again by directing him to produce the permit copy and to read it as to mark it has to take. On that point, you will accept.
Sir, you first examine this aspect. Then, if you require, we can dispose it here or we'll send it back. That's not a difficulty. Sir, you have understood this case. You have to counter that submission and you have to counter the judgment of this division bench, which he is relying on. It is not the question of not having permit. It is a question of going beyond the restricted zone of permit. He is having permit, but he was playing elsewhere. That's your case. Hello, Mr. Nagesh.
Permit violation of conditions. Cannot produce the permit. That he has filed return statement. Not late evidence. To complete that aspect.
You are not late evidence.
I am not late evidence. That is the only defect here. That is the other things they cannot. Therefore, he will not make the open demand to that extent. That is not that. So this ITRA for me 70,000 rupees. That is, I paid the insurance policy.
RW1 ಯಾರು ಮತ್ತೆ? RW1 is owner, is it? ನೀವೇ ಅಲ್ವೇನ್ರಿ ಓನರ್? Who's that? So you are the owner.
I am the owner.
You are not examined. ಮತ್ತೆ ಅವರ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ವಾ?
Evidence because if I locality and objection right, then he keep quiet. That's what the court says. It's not like that.
Send it back for evidence, because that's a crucial evidence of permit and no permit.
This can't get the criminal exam because the claimant also now correct 21 and but it will correct 21 last.
We'll dispose it also. Third learned counsel Sri Vishwendraya HC for the appellant insurance company and Sri M.E. Nagesh. What about R1? So she has no role. And Sri M.E. Nagesh for respondent number 2, owner of the offending vehicle. It is the contention of learned counsel for the appellant that the offending vehicle has violated the permit and therefore is liable. The insurance company is liable to recover, pay and then recover in view of the judgment of the Honorable Apex Court. Full stop. He further contends that the order of the tribunal, award of the tribunal is erroneous and arbitrary. It is also contended by the learned counsel for the appellant that the owner of the vehicle number with regard to liability of the insurance company, that is the appellant hearing. Full stop. Per contra, learned counsel appearing for the respondent number 2, Sri Nagesh submits contents that correct. Yes. Contents that he, though has filed the statement of objections to the claim petition, has not conducted, has not stepped into the witness box to adduce evidence. Therefore, an opportunity may be given to him to adduce evidence and produce the necessary material documents in support of his case. It is his contention that he has the necessary permit and license to run this vehicle. Therefore, there is no liability. No liability could be cast on him. These are factual matters which will have to be decided by adducing evidence. Admittedly, in the present case, the respondent number 2 has not adduced evidence. Therefore, this crucial matter requires consideration by the tribunal for recording of evidence of respondent number 2, the offending owner of the vehicle. Accordingly, I deem it appropriate to remand this matter to the tribunal for consideration of recording of evidence of both the parties. Only with regard to liability. Only with regard to liability. How much time you want? Written through 3 months. Accordingly, this matter is remanded to the 6th Additional District and Sessions Judge MACT DK Mangaluru. The district judge shall, the tribunal shall decide the matter within a period of 3 months on receipt of the copy of this order and the file of this. Trial court bandhi the records, on receipt of the entire trial court records by giving proper opportunity to both parties to adduce evidence in the matter, which is restricted only to liability. Amount deposit madidira. Amount in deposit to be transmitted to the tribunal. The registry to forthwith transfer the trial court records to the tribunal. Owner's appeal challenging the liability. So you are saddled with liability as the owner of the offending vehicle. Who's your opponent? All HS Lingaraju for R6. Trial court record bandide. Next week hakana. Learned counsel Sri Vijay Kumar SC is present before the court physically. Learned counsel for respondent number 6 submits certain inconvenience. Hence relist this matter after 10 days. Gurudev Prasad. Yelli nim friend Kishore Krishna Kishore, yes. State Commission alli idare. Records ಬೇಕೇನಾ? The major discrepancy? Disability consider ಮಾಡಿಲ್ಲ. Heard learned counsel for the appellant Shri Gurudev Prasad KT. There is no representation on behalf of respondent number 1. R2 ಬೇಕೇನೋ? R2 is required. ಆಗಿಲ್ಲ ತೋರಿಸ್ತಾ ಇದೆಯಲ್ಲ ಹೆಸರು. Who's R2? You are the claimant. R1 is insurer. Learned counsel for the appellant submits that the notice to respondent number 2 may be dispensed. ಹೌದು dispensation ಕೇಳಬೇಕಲ್ಲ ಮತ್ತೆ. Whether he was ex parte before the trial court. In view of the fact that the respondent number 2 was placed ex parte and did not participate before the tribunal, notice to respondent number 2 is dispensed with. 64 Gurudev. The registry to secure the trial court records. Ellinda? Bangalore. Release next week. Yaar new year alva? All right. Released after 2 weeks. Next matter. Vijay Kumar. All right. Heard learned counsel for the appellant. Registry to secure the trial court records. 67. Satisha. Ravi Shankar. Yes, yes. Yes, sir. Claimants appeal. ಅವ್ರು ಕೊಡ್ತಾರಲ್ಲ, ನೀವು ಕೇಳಿದಷ್ಟು ಕೊಡ್ತಾರ ಅವರು? ಏನ್ ವಾಟ್ ಇಸ್ ದ ಇಂಜುರಿ? 2018. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಇಲ್ಲ, ಇನ್ಕಮ್ ಪೇಜ್ ನಂಬರ್ ಎಲ್ಲಿದೆ? 7,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಂಟರ್ನಲ್ ಪೇಜ್ 28. Accordant 2018. So this should be 12,500. What is the age? 30. Madam, age is 35 years. So you 15, huh? 16. How much is taken? Where is that calculation of the multiplier in this judgment? 17, huh? Illre. 35 years, multiplier is taken as 15. It should be 16. Yes? Are you disputing? Correct. Sarla Verma 35, 16 years. Correct. Next. Ilre adaitala disability 15. 13% is correct. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 13 correct. Okay, this is correct. Next. No, how many days inpatient? 9 days. What is this? So based on the 12,500, 9 days. All right. Now come to the heads in page 19. Pain and suffering. You have not filed any appeal. You are not filed, Allah. Next, towards medical expense, actual kottidara. Towards conveyance, nursing care, nourishment, towards other incidental expenses. 9 days, Ray. 90. ನೀವು ಕೇಳಿ, I mean, what is your enhancement you are seeking in this table? Laid down period 50,000. How many days? How many months? 5 months. So 12,500 into 5. Just take it. 62. So this will become 62,500. Correct, Mr. Ravi Shankar? Instead of 50,000. Permanent disability. Correct, yeah? All right. Towards inconvenience, discomfort, and future amenities, 35. Yenike? Towards inconvenience, discomfort, and future amenities. Sir, in pain and suffering, you have been given 90,000. I think that is on the higher side. Now the question is, they have not challenged it. So we will adjust that. I need not permit it to Ravi Shankar. ಅದು ನಿಮ್ಮ ಇಷ್ಟ. ನೀವು ಹಾಕಾಗಿದ್ರೆ ಹಾಕಿ, ನೀವು ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ನೋ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಮಾಡ್ತೀವಿ. ಸರಿ ಇದೆ ಸರ್. So we'll adjust that there. So where is the contributory negligence regarding liability? Because of no driving license. So that becomes contributory?
Because he has colluded with the lorry and two-wheeler.
Collided. Now, no, because he doesn't have a driving license, will that amount to contributory negligence?
He has to be drive this one Tribunal and also for this two-wheeler because he has put up in the road for the two-wheeler.
What does the law say, sir? What is your?
And he has put on the road of this.
No. Para 36 regarding 10% contributory negligence is only on the ground that he doesn't have license. No, whether it is that the point of law? What?
Because if we go without helmet, without this one, we can go on the highway and other things.
Mr. Ravi Shankar, if he doesn't wear helmet, if he doesn't have license, there is a.
You cannot kill the person. That's radio license. I am not the point of this one. It is the because if you don't have license, you can't kill the person. This one. But on the put up in the public road, you must also separate the wife and the person. That's why they.
What is the latest judgment of the Honorable Apex Court on? No, if I vaguely remember, I think the Honorable Apex Court headed by His Lordship, headed by His Lordship, the Chief Justice of India. Even if he doesn't have a driving license, unless he has contributed to the accident, only then he'll. So where is the question of 10% liability on him? No, then 90% or 100% ಬರ್ಬೇಕು ಅವ್ರಿಗೆ. So we'll make it 100%. All right. You are not argued, he is arguing for you. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕ್ರಿ. What's your name? Satisha. You have to come prepared, sir. You don't burn some midnight oil, do some research and counter. They are every day immersed in this. They know in and out more than you and me. Go and find out the judgment and give it to my court officer. Even if you don't have driving license, contributory negligence cannot be attributed to you. Sir, whether any evidence led by you that he has contributed?
The owner is not this one company. And you given it by this one. How can we go and decrease each and every time you are not expert? Because if you cooperate, then only I can do it because he only received the criminal notice as well as this notice, everything. So it was not right. We only notice your lordship's order and criminal order. That's all. That is drawback of ours.
When will you give? Shall we dispose it off or?
Because I know the.
Illa, you may know. No, this court should not go anything contrary to the law. Because I remember vaguely reading somewhere. Correct? So we'll go on that. No, if I remember right, in that case, there were 3 persons in a two-wheeler. So even if there are 3, Correct. So even in case of triple riding, it has to be proved that because of triple riding, these people have caused.
We are not unable to give the evidence before the court as per the-
Unless ಅವ್ರು ಬಂದ್ರೇನೆ ನೀವು ಮಾಡಕ್ಕಾಗತ್ತೆ, otherwise.
That is enough. Because he can go in a display of that day. You must cautious and right away. That's the hearing. You must pay the compensation full. Not every. And this case also goes like that.
So this 90%, 10% contributory negligence against him or your party.
90%.
Illa. Now the 10% of you're a petitioner.
He only reading the vehicle.
Is it nimde yardo? Which is your offending vehicle?
Offending vehicle is a
Car.
This one.
Car or they? All right. So we'll remove this 100% liability. Barkoli. Come prepared and give that judgment. Go and do some hard work, research. Barkoli heard learned counsel Sri Satisha T on behalf of the appellant claimant and Sri C.R. Ravishankar and learned counsel Sri R. Ravishankar for respondent number 2, insurer. It is a contention of learned counsel for the appellant that the judgment award passed by the tribunal is contrary to facts and evidence on record and hence requires enhancement as meager amount of compensation is awarded. He further contends that the tribunal has erred in awarding inadequate compensation commensurate to the injury and damage suffered by the appellant claimant. ಏನ್ರಿ ಇದು tribunal acted niggardly ಅಂದ್ರೆ ಏನು? What is this? Who's madam, you are having phone? What is the meaning? Ali check ಮಾಡಿ niggard, niggardly. Carelessly, na? Niggardly. niggardly. Huh? Ungenerous with money. Niggardly, niggardly. ಇಲ್ಲ ungenerous with money ಅಂತಿದೆ. Mean. No. Niggardly meaning is very clear. Ungenerously with mean. Niggardly is a abusive word for this. Normally they for nigger is for those African people, the Negroes, nigger. So it is a abuse. Anyway, I learned some word. It is a contention of learned counsel for the appellant that the tribunal has erred in taking proper income of the appellant for the accidental year 2018 and has erred in taking notional income of 10,000 rupees, whereas 12,500 is the notional income for the year 2018. Accordingly, I deem it appropriate to adopt the income of 12,500 as notional income for the accidental year which has taken place in the year 2018. Learned counsel further contends that the multiplier adopted by the tribunal is erroneous, and instead of 15, the appropriate multiplier would be 16, which I deem it correct to apply the multiplier of 16 instead of 15. The percentage of disability is not disputed. Accordingly, 13 is the correct percentage of disability. suffered by the appellant claimant. The counsel for the appellant also contends that the tribunal is erred in imputing 10% of liability for contributory negligence, which is based solely on the ground that the appellant claimant was not holding a valid license to drive two-wheeler. He contends that this may not be appropriate. Hence, the liability of 10% to be waived off and the entire liability to be fastened on the insurer. Full stop. Therefore, in view of the change in the income and the application of multiplier, the table of calculation would change, and accordingly it is modified from rupees 5,58,410 to so and so, with the above aforesaid modifications. Interest test ಕೊಟ್ಟಿದ್ದಾರೆ 6%. All other conditions will stand as per the orders of award of the tribunal. Any amount deposited here? All in that. Anything else? That's all? That's all? All right. So you have to thank Mr. Ravi Shankar for arguing for you. Yes. Yes. No, fairly you cannot. These are matters which you have to fairly submit. Nodi, just check the judgment of the apex court. Correct, I think. Correct. Correct.
Noting that 20% negligence.
Proof. Correct. Merely by traveling, they will be liable for the penalty or which is prescribed under the Act. Correct. Yes, sir. Aita matters. Yours, which number? 57. Yes, sir. You are ready, sir. Note. 57. Yes, Mr. Sidramaya. Sir, ನೋಡಿದ್ದೀರಾ Mr. Hegde? ನೋಡಿ ಮಾತು. What is your notional income taken? Notional income ತಗೊಂಡ್ರಾ? How much? Paragraph? ಇಲ್ಲ, where is 15 ಅಲ್ಲ? 15,000. Tribunal has given 9,000. What is the year of accident? Ah. 11,000 is the income for 2017. Yes, sir. What is your avocation, sir? Huh? I'm unable to hear you. BD. Roller. BD rolling. Oh, that was daily wages.
other aspect is concerned, the percentage of disability and
So okay, so we'll make it as 11,000. Yes. So what is the multiplier? 18 is correct. What is the age? 24 years. Multiplier is 18, correct? Huh? $18 is correct. 1 lakh? Adenge. What is the disability? So no dispute on that? All right. Ah. 2,37,600. Correct. So that changes. What is next? Come to the table. Now you come to the table. Pain and suffering. How many days inpatient? Correct ideyalla. Okay. Loss of income also will change. So 2 months is less salary. Fracture of 3 months fracture. Anything you go and get admitted. Recovery process will be 3 months, sir. You can't straight away go. So we'll make it 11,000 into 3. So 11,000 into 3. 33,000 instead of 18,000. Medical conveyance, nutrition, attendant charges. All right. 10,000. Future medical expense ಏನಿದೆ? No. No, even otherwise, if there is any implant, you have to go to the doctor. You have to get it removed. So there will be just an increase, another 10,000. All right, 5,000. Yes, sir. All right. All other things will stand same. Whatever it may be, whatever we have decided now, you give a memo of whatever we now discussed and serve a copy on him. Third, Lord Council. You kindly be. Now what is the order of release of amount? Anything is been ordered to be kept? Yes. Heard Learned Council. Shri V.B. Sidramaya and Shri Learned Council Hegde Mughal Kund for R1 insurer. It's contended that the order of the tribunal is erroneous and requires interference by this court. Then counsel contends that the income adopted by the tribunal is on the lower side, as the accident having occurred during the year 2017. In the month of December, the income ought to have been taken at 12,500, which is applicable for the year 2018. However, learned counsel for the insurer, respondent number 2, vehemently opposes the same, as the table of notional income has been fixed for the year 2017, which is rupees 11,000, and accordingly, this court also feels that the income taken by the tribunal is on the lower side. Income to be enhanced from 9,000 to rupees 11,000 per month. 11,000. The multiplier adopted by the tribunal is correct at 18 multiplier as per the judgment of the Honorable Apex Court in Sarla Verma's case. There is no dispute with regard to the disability of 10% incurred by the appellant claimant. Under the head pain and suffering is enhanced from 30,000 to 40,000. Loss of income during treatment is enhanced from 18,000 to 33,000. That is within bracket 11,000 into 3. Loss of future happiness and amenities is enhanced by 10,000. That is from 20,000 to 30,000. Future medical expenses is enhanced by 5,000 from 15,000 to 20,000. Stop. The appeal is partly allowed, enhancing the compensation from rupees 3,17,400 to so and so. ಎಷ್ಟಾಗುತ್ತೆ enhanced compensation? So the all other terms and conditions imposed by the tribunal shall stand intact. The enhanced compensation amount shall be released in favor of the appellant claimant. That's all. Memo on that, Mr. Sidramaya. Sitaram Rao, you are appearing for this is by appeal by insurance. ನೀವು ಹಾಕಿದ್ದೀರಾ? ಹೇಳಿ ನಂಬರ್. 22. Learned counsel Shri Naresh Kumar on behalf of G. Manivannan submits that the claimant is also preferred an appeal aggrieved by the judgment and award of the tribunal in MFA 1588 of 2022. Registry is directed to list this matter along with MFA 1588 of 22. Stena, let it come along with it. Is anything else? Mr. Hegde, I think that is the correct position of law. Because unless you prove material evidence, correct, or no license, correct, he will be liable for other penalties which are there in the correct. Yes, or whether drunk driving or what. As I think the judgment of the Apex Court headed by His Lordship. I vaguely remember reading it, but I then of course it can be considered. Then also it has to be proved merely by charge sheet. It has to be proved. Because we don't want to take different views, for one court taking one view or my learned predecessor taking one view. it will not be proper. Yes. Madam.